All right, it's time for Political Roundtable, Mainland 98.3 FM. My name is Sahid Fohad, the show where we look at the major issues in the political space. We have two hot topics today, and I'm hoping that time will permit us to really go deep into these two very, very important issues in the political life of Nigeria. Eventually, the petitions, the presidential elections petitions court, the tribunal has given its judgment. It was a unanimous judgment. The five justices of the Court of Appeal sitting as the Presidential Election Petitions Tribunal ruled dismissing all of the petitions brought before it as far as the last presidential elections are concerned. The petitions by the APM, the Allied People's Movement, the Labour Party, and the People's Democratic Party, the PDP. So again, I think there's been a lot of talk about that particular judgment. It's probably one of the longest presidential election judgments that we've ever witnessed in the country. It took almost 14 winner will most often coast to victory in the election tribunal. Today's, the verdict of the appeal court should be a reason for sober reflection by all, especially for the parties in the court, their lawyers, and the lovers of democracy. The petitions could have been decided purely on points of law and within a few days of the election. There can be no real victory in the resolution of the legal issues by the court when the fabric of our democratic engagement seems to have been hijacked and compromised. Part of the lesson in this process is for us to go back and review the electoral process and the litigations following it. INEC, as it is presently constituted, cannot birth any credible election in Nigeria. End of quote. Ebun Adegboruwa SAN. And that's the lead for me to the second topic for this evening, which is electoral reforms. The Justice Uwais Electoral Committee report of 2008 is still somewhere, gathering more dust. And so we're asking ourselves, are we going to go into the next 4 years with the same cycle of election rigging, INEC reneging on its promise, its guideline is no guideline, we go to courts, and at the end of the day, nothing happens? Or we take it as a major point of discussion, we set it as our agenda, whether as politicians, as journalists, as ordinary people, civil society organizations, to call for immediate reforms of our electoral process. So, is this the time to reform the entire electoral process for better elections in the year 2027? That will be the second issue for discussion this evening. Like I said, the first issue is on the judgment of the presidential elections petition court. I have Barrister Curtis Adigba with us in the studio already. Good evening, Barrister Curtis Adigba.
Good evening. Thanks for having me.
All right. We also have Joseph Folorunsho with us in the studio this evening. Joseph, it's nice to have him in the studio.
Good evening, and good evening, Lagos.
All right, we're supposed to have Mr. ʟɔlálẹ́kan Òní, a politician and also a public affairs analyst, join us in the studio this evening, but he got stuck somewhere on the Lagos-Ibadan Expressway, but I'm sure he's listening to us. Nuruddin Adegberu is taking a deserved rest, but I'm sure he's also listening to the show wherever he is this evening. Well, the show is interactive. We're streaming the show live on Facebook and on YouTube, and so you can be a part of the show by, of course, dropping your comments on our Facebook platform, Mainland FM 98.3. Yes, just drop your comments and contributions on these two issues on our Facebook platform. At the right time, of course, we'll start to read out your comments and contributions. Well, for YouTube, it is Mainland 98.3 FM. You can also watch us live on YouTube and drop your comments and contributions on the two topics this evening. We'll take the first one. Like I said, the Presidential Elections Petition Court, PEPC, in a landmark decision on Wednesday, dismissed the petitions of the Labour Party, the PDP, and the Allied People's Movement and their candidates against the election of President Bola Ahmed Tinubu. Well, the highlights of the judgment that Obi Labour Party failed to prove rigging and overvoting. That all of the allegations of rigging and overvoting, both the Labour Party and its candidate was not able to prove all of that. So there was no substantial evidence to prove that indeed there was rigging and overvoting. The second one for me, highlight now of the judgment, is that portions of Obi's petitions were vague, imprecise, bereft of particular materials and evidence. The third one for me, Obi, well, one of the things that was also decided upon was that, well, the issues of nomination, whether Obi was validly nominated or not, was also dispensed with. And it was said that, look, it was an inter-party matter, a pre-election matter, and so it was not for...
That's where I have the biggest problem.
We are going to go into every... Again, that's why we're bringing all of these issues. So luckily, we have Barrister Curtis, who is a lawyer here to either agree or disagree with that judgment. Just hold your thoughts, Barrister Curtis. I know you are so much anxious to...
I'm not even anxious about it. I mean, I told you the train already left the station.
The station a long time
before these guys arrived with their tickets. I never expected anything different to come from tribunal. I told people, that, look, in Africa, once somebody has been sworn in,
all right,
you're only wasting your time. At the presidential level,
okay,
the only place it has happened in Africa so far was Kenya.
Kenya, yes.
You remember? And that was because the guy in the system room or the data room was murdered. And so they didn't have the full data. And that's why the Constitutional Court ordered a fresh election. Even the last election that William Ruto won
Won,
by
yeah.
less than half percentage point. It wasn't an odd. The president was against that victory. Uhuru was against
Oh,
the
yeah,
victory.
Kenyatta, yeah.
Raila
Odinga.
was
Raila
also very
Odinga.
powerful with his lawyers, but the Constitutional Court put the country first. So, look, finish.
Okay, let's just, we're going to go straight to these key issues. So, again, the issue of the nominations of Shettima was also decided upon, and what the court basically said was that, look, Shettima was validly nominated as APC vice presidential candidate, and that those were also pre-election matters that, should not be brought before, and an inter-party matter anyways, and the APM, they didn't have the locals to be, to talk about that or raise that at the presidential elections petitions court. And then there was the issue of the no evidence. Tinubu was convicted in the US for drug trafficking. That, look, it was a civil matter, it was a civil forfeiture, and there was no criminal indictment of any kind as far as the drug case was concerned. So Tinubu not indicted, arraigned, or tried or convicted in the US, and that the $460,000 forfeiture is a civil matter, not a criminal conviction. And then INEC can be forced to transmit election results electronically. That's also one decision that came.
Nobody forced them. They promised to do it based on the law.
But that it was discretionary, really. It was not.
It wasn't.
So we're going to look at that too. It was so again. There was also the issue of the 25% votes in Abuja, and what the courts basically said was that, look, Abuja should be considered as a state. As far as elections are concerned,
where's Abuja's governor?
So and that on election matters, that it should be considered as and that, look, residents of Abuja, voters are not special and not
I think you should
yes.
take this issue one by one.
Yes.
So that we don't lose track.
That's what I'm saying. That let's just take it one after the other. Now, again, OP's petition was dismissed. All of the allegations were thrown aside. So let's take it one after the other. We have the one of Obi and the Labour Party not being able to prove, substantially that there was rigging, and that in areas where they had pointed out rigging, there was no evidence. They could not substantiate it with any evidence. So, Mr. Curtis, do you think that judgment was in order?
The Supreme Court laid down the principle in Jim Mobodo against CC or no? I think in 1983. Where he said, rigging is a criminal offense, and once you allege that the election was rigged, the onus of proof, the burden of proof, is beyond all reasonable doubt. And that, of course, is very difficult to prove in a presidential election, because there are key elements. You see, the law is not about sentiments, okay? But you can deliver the law through sentiments, but the law is not principally about sentiments. So when you go to court, there are basic ingredients that you must prove to establish that a particular thing happened. In a criminal trial, for instance, let's say in a murder, you may have witnessed a murder, somebody driving at a high speed, or somebody shot somebody. You saw it. So you saw the physical act. You saw the man die. So you can say that he committed murder.
Murder, yes.
But when he gets to court, the court will be called upon to examine two critical elements. The actus reus, which is the action that you witness, and then the mens rea, the mental part of it.
Yeah.
The intention. Did he have the intention to kill?
Whether it was premeditated?
Yes. So, if you cannot prove these key critical elements together, okay? If he had the action took place but there was no intention, so somebody is driving on the road and the other person runs across the road and he gets killed, all right? There was murder, he died, but was there intention to kill the person? It's a different thing if the law says here you should not exceed 20 kilometers per hour, and you are doing 90 kilometers per hour. The law will say he ought to have known that he shouldn't be doing that kind of speed on that road. So this was where Labour Party and others ran into trouble, because you now had to prove that in fact the riggings that rigging happened all over
because
the
according to the
and there are those who carried out the rigging
were members of the opposition
or they
in favor of
or did it to the benefit of the candidate who benefited from it.
Yeah,
that's very difficult. Okay, so I will cut them slack on that. But
the 5 justices.
But I also want listeners to understand something. That we also followed the activities in the tribunal. And sometimes we saw evidence that were overwhelming. But here's the problem. No matter the evidence a lawyer lays before the court, you know, the justices just sit there, they listen to the witnesses, they saw their demeanor, they took in the evidence, they applied the Evidence Act, they applied precedent, they applied the written law to all these things. But there is one thing that is more critical than all this, which is the mind of the judge. How does the judge attach weight
to an evidence?
An evidence. And that is where things usually happen. Because a judge can listen to all this evidence
and still think it's not substantial.
Pervasive evidence. And because his mind is already made up that this is the direction I want to go, he will attach very small weight and say, oh, you know, you didn't prove the case. But you know the good thing about this? This is not the final court on this issue. Not that I'm expecting anything fundamentally different.
At the Supreme Court?
But at least the body of our laws will be improved. And I believe that the justices of the Supreme Court are more experienced, more nuanced. You understand?
We have more numbers to 7
more
of them.
courageous. And they have nothing to fear anymore. They are not seeking promotion to any other court. These justices who sat down here are also thinking about their political future or their judicial future, because almost all of them are primed for the Supreme Court. And every judge or justice wants to get to the Supreme Court. And so at the back of their mind is, if we do this, if we go the other way around, are we likely to be nominated for the Supreme Court?
So you think you are alluding to that there could be personal considerations?
So what I'm saying is that no matter the evidence you lay before the court, it is the judge who will attach weight to that evidence and decide whether the evidence is convincing or not convincing. So sometimes when you hear that we didn't have enough evidence, do you understand? The job of a lawyer is to lay before the court the evidence that he has. It is the duty of the judge to attach weight to that evidence. And that's why sometimes you hear that a judgment was set aside by a higher court because they will say the judges or the justices erred in law. In that they did not consider these critical elements. So I'm not here to sit in judgment over the judgment of the learned justices. But because Nigerians need to understand what happened, this is why we are doing this.
Of course, yes.
And I'm saying that it's very difficult to prove beyond all reasonable doubt that rigging happened in an election and that the beneficiary was the winner and that those who carried out the rigging on his behalf or on his direction.
All right.
That's where the problem is.
That's the problem again, because just like Mr. Curtis has said, Joseph Olorunsho, the court noted that whereas Obi and the Labour Party insisted that election was rigged in about 18,000 polling units across the federation, they were unable to state the exact locations of the said polling units. And it further held that Obi's allegation that fictitious results were recorded for the president, Bola Ahmed Tinubu, and the APC by the INEC was not proven. More so, it held that the petitioners were unable to state the figures they claimed were reduced from election results they gathered in different states of the federation, especially in Ondo, Oyo, Rivers, Yobe, Borno, Taraba, Osun, and Lagos State. And do you think that, like Mr. Curtis said, how do you, again, we're working with over 174,000 polling units across the federation. Just while the Presidential Elections Petition Court was delivering its own judgment, Kogi State, one of a very major judgment, was also delivered by the Elections Tribunal for the National Assembly positions to the Senate. Natasha Akpoti was declared winner of the PDP as against what was declared, the APC candidate was declared winner in Kogi Central. And there are people who have said that, look, when it comes to a smaller number of units, senatorial zone, for example, has how many polling units to work with?
That's not even the reason. The reason is that the judges are more courageous when it's not presidential
but I'm taking it, Joseph, I'm taking it from the argument that, look, to provide evidence to substantiate your allegations at a presidential election in Nigeria, the way it's presently structured, will be extremely difficult, really, because these things, a lot of them were manually collated. You know, the idea of electronic transmission of results and all, we said it here on this table.
I'm not taking too much time.
Yes.
The reason why it is almost impossible to prove anything is that those who have the data, who have the documents,
are the ones who are also respondents.
They are against the petitioner.
No, because they are,
because they see it as a challenge to their work. Look at part of the judgment which we are going to mention later. Did you see that the justices said that the petitioners failed to front load certain documents?
Documents, yes.
Documents that they issued a subpoena
to get
on INEC to give to these guys, and INEC didn't want to give. How could they have front loaded it?
So again, we're still going to talk. But we're still going to talk about what Mr. ʞʞʞʞ said about reviewing our laws and also the entire electoral process. That's the second part, really. But Joseph Folonshaw, how difficult do you think it is for anybody to petition a presidential election in Nigeria?
How difficult do we make the situation be? Not that the situation is difficult. We, Nigeria, or the INEC, and we make a situation very complex and the rest of it. If you look at it, I think the party or the candidate would not be allowed to be passing through all this stress. The INEC, the security agency, would have come over and say, okay, these are the evidence that we have, that these are the people that we're trying to sabotage the system, and we have apprehended, arrested some of them, and that is the reason INEC will come, okay, there should be consequences for some of these elements that are trying to spoil some of our work. But for what we do get is this: the security agency will be rationalizing why that result, that scenario, should be maintained. INEC is making it very, very difficult to say, oh, we made a mistake in A, B, C. I think people that make us to make that mistake, either within or outside, we want any person that can help us to make sure that they face the consequence of their action.
Of their actions, yeah.
It's not there. And the reason is, I think the reason is just simply, as in Nigeria, I may be wrong, I don't think we actually have a defined policy.
Okay.
You understand? Nigeria is going to conduct election. This election should be an election that America should look at and say, how do we break this kind of record? Indians should look and say, oh, if we want to conduct our own election, how do we break this kind of record? Canada, but Nigeria we do our election as if we are not part of this
the global community and other democratic nations.
The rule that we set, we flout all those rules. Come to INEC, and they say they are going to. What INEC promised Nigeria is saying this election is going to be one of the best elections.
They are still insisting that it's probably the best in recent time. That's what INEC is still saying.
Just the one that where the Kogi now that the court is saying that the result is.
No, we're going to get to.
What I'm saying is this.
Yes.
The tribunal, to me, they are part of Nigeria. They are Nigeria. They are individual here. Just as what Barrister Court is saying, they have life aspiration, and they equally look at it that is the system there to protect them. Like look at, I think it was in US, Donald Trump was trying to do something. A judge that know that this is the president. We're telling him, Mr. Man, you are president, but this will not work.
Fly with me, yeah.
Will not fly. And the system support him, and he's not afraid that he will lose his or her job. So, but the system here is as if there was a day I was in court in this is Sabo High Court. I don't look at it. The case was very sensitive case.
Very case, yeah.
At the end of the day, the judge came out of the court after the section with one police at the front and a driver. That's 3 people. And that's is how the environment is so porous, and you are seeing a judge handling this kind of case. And look at the protection of the job. But when you see a local government chairman moving, you see at least minimum of including his own vehicle, maybe 3 or 4 vehicles.
So are you trying to say that maybe the justices were coerced or they were afraid of something?
No, see, Fuad, life is sweet too.
Well, okay.
Life
Okay,
is.
I'm going to.
I think if you look at the 3 arms of government,
Yes.
the judiciary is actually at a disadvantage when it comes to distribution of government resources
And largesse
and all that. They only take prime position when they have to give decision to
When
keep
cases are brought
politicians
before them,
in power, either at the executive or legislative level, because we know this is something we've been talking about, and that's why we keep talking about judicial reforms.
Reforms, yes.
And that's why the justices were angry by the popular all eyes on the judiciary. I mean, this has always been happening. You recall that in 1979, the ᴜsᴜ case, eyes were on the judiciary. But the reason why you didn't hear it so much, there was no social media then.
And the verdict was also rejected by the petitioners.
One funny thing is that some of the justices were so icked by what they saw on social media. And I was laughing. I said, how come my lordships saw these things on social media and yet they didn't see the evidence in the court? They see. You understand?
Well, they even responded to it by mentioning it. You expect to go and harvest evidence on social media.
So I mean, yes.
But again, we're going to look at the second issue here. Which is the criminal forfeiture.
Look, I have about 5. I listed about 5, 6 issues.
Okay, let's have your own issues
that I had with that judgment.
All right.
Number one, the issue of qualification for office, eligibility.
All right.
That the court seemed to be saying all that matters now, as far as eligibility is concerned in Nigeria, is you being presented by a political party.
Whatever happened before then.
Yes. I mean, because you see,
on the case before them,
the constitution is very clear. And only the courts can look into eligibility, who is qualified. Okay?
I'm with you.
So if a party feels a candidate that is not qualified to run for any office, now, I have problem with the justice saying, because the person challenging this qualification is not a member of that party.
It's an inter-party matter and you are not supposed to question it.
The constitution of the country is higher than the party's constitution that was used to pre-qualify that candidate. But
you are talking about having the local standard to really, challenge a case when you are not a member of the party.
When they say that the matter should go to the Federal High Court, that it has exclusive jurisdiction, they already killed the matter by saying, if you are not a member of the political party, you cannot even challenge
it, yes.
But we are citizens.
Not even jurisdiction now.
You understand? We are citizens of this country. And the constitution is very clear. So I think that issue should be looked upon. The second issue, for me, is that saying that documents should have been front-loaded. Documents that the people, INEC that conducted the election, didn't want the petitioners to have access to. In fact, INEC was acting like the party that is being tried. INEC didn't act like, they
were responding. They were the first respondent to the suit. So
you understand? So
they were joined as a party.
No, what they were supposed to do is we conducted the election, and these are the data we harvested from our activities. But they took a partial position defending.
Yeah, if they were a party to a suit as a respondent, questioning what they did in declaring the results. Is there any other position they could have taken? How could they have handled it better?
Hold on. They could have taken a position that we conducted the election, we have nothing to hide, we bring in all the documents to court. Yeah. But why did the court have to issue a subpoena on them before they brought those documents and gave to the petitioners? And those were the same documents that the same justices were saying should have been front-loaded.
Good. So you thought INEC was a bit...
yeah.
All right.
Now, the other thing is that you were talking about transmission of results.
Electronic transmission of results.
What was all the hue and cry about the amendment of the Electoral
Act? Yes.
It was to accommodate electronic transmission
of results.
And when you go and look at the Electoral Act, Section 47, subsection 2, and Section 64, subsection 4, the language deployed there was shall, imposing a duty on INEC. And then we spent billions to procure these beavers. Now, if the court is saying, all right, that INEC had no duty at all, INEC can choose to do manual collation and didn't have to transmit any result. So what is the purpose of that law? Now, the other point that I also didn't agree with them is on the issue of Abuja.
Okay.
Now, the argument appears
25%, whether there's any special status.
The argument appeared to be anchored on superiority of voters. Voters in Abuja are not superior to other voters in Nigeria. And that's a mischaracterization of the issue. The issue is not superiority of voters. The issue is legality. It's like saying, if somebody won majority of votes in the United States, and we have seen that happen so many times, but loses the Electoral College vote.
Yeah.
I'm with you.
Is the argument that the Electoral College vote is more superior
than the popular votes?
No. That was because from the beginning, the system incorporated the two, popular and electoral votes.
College votes, yeah.
Now, you need to win both
to become president.
But in the absence of both, if we won the Electoral College vote alone, you'll be president. The question is that those who voted in the swing states to swing the election in favor of the candidate who won more electoral votes,
are they more important?
Are they more important or more superior to other voters?
But Mr. Curtis, you know, we've also analyzed it here, talking about weighted votes.
Yes.
Which some constitutions of other countries acknowledge and respect.
But we don't have that.
We don't have that yet. So maybe that's the reason why the justices are saying that.
Let me anchor my point.
If you understand what I'm saying.
When you go to the provision of the
Constitution, yes,
it lists 3 conditions. Number 1, that in an election involving 2 or more candidates, for a winner to emerge in the presidential election, he must have simple majority of votes cast at the election.
An election, yes.
That's 1. And then, note it,
yes,
at least 2/3, no, at least a quarter
of votes,
into 2/3,
and the
Abuja.
And the FCT.
So we accepted the first but we are rejecting the second one. Now my question is, if a man had a simple majority of votes and he did not win a quarter of vote in at least
would he have been declared president?
Would he have been declared the president? And this is why the Supreme Court will have to take a look
at this particular case,
this Abuja issue, because the issue is not
and resolve it fully.
The issue is not superiority.
Okay.
The framers of the Constitution,
what was their intention?
They knew that Abuja is the bellwether of Nigerian politics, is the melting point of all Nigerians. They wanted to give the winning candidate legitimacy. Look, the reason why all this is at play is because the winner did not meet 25%.
Maybe we'll not be talking about it.
No, we wouldn't have been talking about it. And so this whole argument that, you know, for the purpose of election, Abuja will be construed as a state. If Abuja will be construed as a state, the Constitution should still have said which
includes Abuja.
Which includes Abuja. And that would have ended
2/3 of the 36 states, 36 states of the FC, which includes Abuja, or Abuja to it.
Includes Abuja.
But again, you know, what would you say to...
You understand?
What would you say to people who say, look, if, for example, you win, you know, simple majority votes, you win the 36 states of the Federation, and you don't have 2/3 of votes, 25% of votes in the FCT. Are you saying that such a person cannot be declared winner because of that provision of the Constitution?
I will answer them that the law is the law. It's not about sentiment. It's not about reasonability. Hillary Clinton beat Donald Trump by 3.2 million votes.
With simple majority votes.
Simple majority of votes. But she lost the presidency.
Because of the Electoral College votes, yeah.
Al Gore beat George Bush with more votes.
Simple majority votes.
He also lost. So do we then say that the Electoral College voters are superior to the popular voters, even though Electoral College voters are also part of, but the swing states? You see, election must be conducted in line with the agreed rules from the beginning,
as determined by
law.
You understand what I'm saying? Which is to be interpreted.
In America, why people don't question the results so much, even though when they are angry, it's because they already agreed from the beginning
what it will be.
Yes.
Irrespective.
And if you look at when the framers of the U.S. Constitution actually sat down, this issue about popular and electoral votes they discussed it for a long time. They didn't want the situation whereby states with bigger population
All right.
will ride roughshod over others. So what they did was to sit down and allocate electoral college votes. Now, and that was how they arrived at the situation that no matter how small your state is, look at the state of Delaware. So small that it has only one House of Rep member.
Yeah.
But it has 3 senators. As small as it is. Why California, with 55 electoral votes, and almost, I think, about 57 House of Rep member, has 3 senators also. But why is nobody complaining? Because these are things that the framers sat down, discussed, and accepted.
Okay, so does that take us to the point, Joseph Folorunsho, that look, there's a lot of lacuna in our election, in our constitution, our laws, the electoral acts that we need to quickly fix. Too many ambiguities. For example, like Barrister Curtis is saying, maybe we should be more clear about what is what really, as far as, you know, what it will require to be declared winner of a presidential election, instead of having these ambiguities, these technicalities, because there are a lot of lawyers who have said that, look, this judgment from the PEPC was more of technicalities than, you know, the law itself. It was more of, oh, you didn't do the right thing at the right time. It's a pre-election matter. This is what it is. You know, more of technicalities than the law itself. So, you think we need to sit back again? Although I don't want to jump the gun because we're still going to talk about reforming the entire process. But did you agree with the fact that, look, people in Abuja, you know, are not anything different from other people of Nigeria when it comes to election matter? And the framers of the Constitution did not intend to make them superior to other Nigerians anywhere in the country. Again, like I told by Sarkozy,
it's not superiority.
The U.S. Constitution, I think the French Constitution and some other countries have an agenda for what is called a weighted vote, where votes from some constituencies and states carry more weight than others. But maybe that's not the case with the framers of our Constitution that, you know, made that statement and Abuja. What do you think?
I think, to me, the challenge we have in Nigeria is afraid of system and process. We don't like to set a system that will help every one of us. Some of these things we call lacuna and the rest of them, I believe they deliberately put those things there so that we can be dodge them and achieve what we want to achieve. That's why there was, I think about some weeks ago, America were complaining that Nigeria should define their electoral law. That there are a lot of opportunity for you
too many things modeled together.
And the other one that we should define it. Look at what Barrister Curtis said between the electoral college and if they come out with anything, nobody complains.
Because it's clear.
Because it is clear. It's an agreement. Look at a state with 1 House of Rep. Look at the same thing with 3 House of Senator and the other big House. These people because they are big, they're supposed to have maybe 6 senators. But they frame it in a way that, nobody should look at it, the system is not favoring me. But our system
two senators. They have 2 senators. All states in America have 2 senators.
But our system...
And the senator's constituency is the entire state.
So, but our system here, which I don't know who will help us, is Nigeria will make a mistake. We will not start rationalizing that. Instead of us to just stand up and say, do you know what? Because of tomorrow, we made a mistake on A, B, C. We believe we should stop this mistake here. But we'll be rationalizing it. You may be surprised that tomorrow, this same Abuja will say 25%. Something will happen. And the national that 25% is correct. This morning, this afternoon, I was coming from somewhere in Sᴜᴜ. Police stopped me and they were, the way they were saying a lot of the announcement. Simple. You flag me for me to you see me trafficking to store. Why are you bringing this iron?
To still further harass
you. And I say, that you are just disgracing everybody. Do you know that if I'm able to take a shot of this or a short video of this iron, and I think we go to court, I will say it's an attempt for you to actually want to take my life. He say, how? I said, but the evidence, see what you already stopped me.
And I was already trying to stop, but you're still trying to.
What I'm saying is this. I think Nigeria is as if we don't like obeying rules and regulations. I think that is the biggest challenge. And any system that did not want to obey rules and regulations we are in deep trouble.
I think you raised a critical point there. You know why litigation arising from elections in the US are few? In most cases, very few. Sometimes they don't even exist. You know why?
I'm with you.
Because on election day, there are judges who are sitting. Let me give you an example. In 2016, while the election was going on in North Carolina, and the governor there and the Republican officials in some counties were reducing the number of hours allowed for voting because they saw that the queue was still long, but they were saying that by this time, and you know what? Lawyers from the Hillary Clinton campaign went to a judge. There and there, the judge ordered that the time for voting be extended. You understand what I'm saying?
with you completely.
So, this, like, I'm buttressing system now. We're talking about system. You see, system is very critical to the survival or progress of any nation. You don't find policemen in the United States mounting roadblocks unless there's an emergency, and then they send out an APB or bullet or public bulletin or something, and with the specific description as to the person they are looking for. Otherwise, you are driving your car, there's a patrol vehicle behind you, there are two of them in the vehicle, the other person is imputing your data from the vehicle tag into their system to see whether you have a standing warrant or your tag has expired or your driver's license has been suspended. It's when something is found that they put on their siren.
They take it further with you.
And then park you and begin to ask you those questions. Or you are driving in a manner that is suspicious, or somebody makes a call to say, we think something is wrong with this guy. You understand? Or you are overspeeding in a location you shouldn't be speeding that way.
That, you are flagged and...
You understand? Or even you are on the fast lane and you are slowing down when you should be on the other lane. These are the things. But here, some people just, either they are bored in their offices or they are looking for something. They just go and mount roadblocks.
And you see IGs upon IGs talking about no roadblocks. And
nobody challenges them.
Well, by Sir because... now, again, we can't talk about all of the major issues in that judgment. But we are looking at the major ones that everybody kept talking about. That was like really what Nigerians are waiting for the justices to deliver judgment on. The issue of the forfeiture, criminal forfeiture or civil forfeiture, as it were, concerning the $460,000 case. The PEPC also dismissed the allegation that President Tinubu was convicted in the United States of America on drug trafficking related charge. The court, in its lead judgment in the joint petition filed by the Labour Party and will be held that the evidence before it established that a $460,000 fine that was imposed on Tinubu US was a civil matter. So do you think that was in order?
I think that is striking. That is striking because if they had ruled or concluded that it was a criminal matter, he won't be qualified to contest for president.
Good.
Because once you have been convicted, one of the conditions for disqualification, you're either bankrupt, you are not a citizen of Nigeria,
you have a criminal conviction.
Criminal conviction can be stopped.
Except you have state pardon.
Now, I didn't listen to the evidence that was presented before the learned justices.
Well, the evidence was basically a document showing forfeiture of some funds by the president.
How they arrived that it was civil and not criminal.
Funds were no, by Sir it was established that funds were forfeited.
That's what I'm saying.
But that forfeiture of funds does not, because there are no criminal convictions. That's what they are saying. So it could have been criminal criminal forfeiture. It was just civil forfeiture.
And I think the Supreme Court, the justices of the Supreme Court, who will sit on appeal, will have the time
to look at that again.
Opportunity
but you think it should be revisited? You think there are still questions around that?
I think all grounds for the ruling, for that judgment, will be examined, especially now that the lawyers for these petitioners have already clearly indicated. In fact, the candidates themselves have spoken and said they are going on court. And again, there's another controversy.
Yes.
We have become a nation of controversy. It's about getting the certified true copy.
Was an issue, but I think they eventually have it. They now have it.
They have it, but what they are saying is that the heading
shows
of what was given to them showed that it was coming from the Tinubu presidential legal team, which means that they had seen the judgment before it came out. That's been raging since yesterday.
Yeah, of course, it's been. In fact, there's an argument between two lawyers, Liberals Oshoma and Barrister Chris Nwokobi, you know, on a particular platform that I would like to play the sound bites, you know, when we get there, which was still on this same argument of, you know, because I'm sure that if
private opinion,
yes, but
as lawyers,
but hopefully we'll deal with that. But so again, we have to wait for the Supreme Court to deal on some of these issues.
Look, the interesting thing here is this: as we know, you know, at the local level. When I say local level, I'm talking about governorship, senatorial, and all that. You know that you have to have a tribunal at the state level to examine these elections, like you heard about Natasha Akpoti's one. Now, a candidate or anybody who is dissatisfied with the judgment of the tribunal can go to the Court of Appeal and ask the Court of Appeal to set it aside. Like you saw in Adeleke's case and Oyetola's case. You know that I think Oyetola won at the tribunal. At
the tribunal, but yes.
At the Court of Appeal, the Court of Appeal set it aside, and then he went to the Supreme
Court and Adeleke won, upheld it.
Supreme Court upheld the tribunal's ruling and set aside. You understand what I'm saying? So the point is that's why this system deliberately provided for this appellate system.
Yes.
So all the issues that lawyers are arguing about, in fact, in our forum,
is a serious
of lawyers,
you have not been able to agree.
We had to even take down the issue completely
because we're going to tear the forum apart.
The language used deployed was hot, divisive. You know, everybody. Everybody feels.
So what you are telling us that even you lawyers are heavily divided on this judgment.
We can't agree.
Okay.
But let me tell you the biggest surprise that I have.
All right.
Coming from the judgment of the tribunal, is that of the 5 justices. There was no one that gave a dissenting.
No dissenting judge. So that's the issue.
And I thought that
the 5 of them unanimous.
I thought that on 1 or 2 issues
there should have been dissenting judgment.
I wanted to see somebody at least to develop.
But if 5 of them just felt that look, all of these issues were frivolous.
You know why these things happen? Because you see, when you are sitting as a panel of justices like Desert, you guys will talk to yourselves, and if you agree, then somebody gets to take the lead and lead the judgment. And then the others will just come and say, I want to...
You know, one of the... Again, I need to take you on because, again, I'm sure you would have discussed this at your different forum. Some lawyers are saying that, the fact that the judges took so much time in reading the judgment, were making mistakes, were making some flip-flops, also showed that, some of the arguments that have been considered frivolous by some lawyers is that, look, maybe because of the flip-flop, they are not the ones that really wrote the judgment.
Fact is that not all of them. You see, you're talking about 708 something pages.
Yes. And
it's not likely that all the justices sat down and read the judgment page to page.
Before reading it out on that day.
What they agreed on to be unanimous are the key points. They probably won't take their time to go through the evidence.
So maybe they have secretaries, and do you think they would not have gone through the entire page before reading it out, Barrister Curtis?
That's why you had somebody who was reading on behalf of others. I think it's just Samani or something.
They took their turns to read, but more of Justice Samani, yes.
Basically,
to harmonize it, yes.
To identify
with the judgment.
And to agree with him. You know that I associate myself with the opinion expressed by my learned brother and all that.
Now let's...
yes. Oga Fuad, my challenge is on that judgment is, this is my own personal opinion, the entire judgment, Nigeria is an orphan in that judgment. Because if you, at least, a country should say, okay, we are delivering job based on the policy, the interest of Nigeria as a country. A lot of young people there who are not expert in law like Barrister Curtis, maybe it's as if you talk of Abuja, 25%, they say, no way. Evidence with all those, they was done, they say, be carry vehicle with all the evidence, they say they took to court, they say all those one, leave them. So there are so many things that people will be looking at. What is, because if a judgment is coming up, people will say, okay, what will be how will the pulse of Nigeria, the country, okay, what is our interest? Just like what we are discussing here, that if you are looking at electoral college, it means that the country as an America have American interest. You understand that?
You are talking about the people's expectations.
Our own Nigeria as a country.
There are politicians that conduct elections in America.
I'm going to
politicians. Let me ask a question, and also this is to our listeners. A lot of people don't tend to understand how critical this point is. Do you believe that if INEC had kept its promise to transmit the results real time from the polling units
There,
to the IREV.
there are people who have also just like INEC has also responded to the fact that look, these were technical glitches.
But can I tell you something?
Yes.
You see, INEC compounded this credibility issue by even keeping quiet on the whole issue until
It was raised.
some people went to television and started saying this is what is going on. So it was an afterthought as far as many people are concerned.
Okay.
Now, the issue about rigging, rigging is scientific somehow. It's not something that what we witness across the country, and that most of us saw, is the fact that some people in some areas were prevented from voting by thugs.
Thugs, yes.
Now, the challenge is, how do you identify the thugs and to whom do you associate them?
And then whatever was done
understand?
as manipulation, how do you now associate it with a particular political party?
And that's why it was so critical that the results that we had, which was known to him, because you see, part of the problem is that when you go to IREV, some results had been tampered with. Some agents alleged that they were forced at gunpoint to sign certain documents. Those were some of the testimonies that the tribunal said they didn't believe, or that it was not conclusive enough.
Yeah, was also
now. So what we need, and we are going to address this in the second topic.
Yes.
How do we improve the electoral process? Because you see, the purpose of the amendment of the Electoral Act that all the civil societies took on President Buhari then, that he didn't want to sign, that it was this and that they know.
I think the major part was electronic transmission of results.
Yes, that he wanted to rig the election for his party and all that. The whole cry about that entire process was about electronic transmission of results.
Which failed at the end of the day.
Which failed. And know that INEC had come out to tell Nigerians, look, we had promised you this, but we're having problem. INEC kept quiet and started collecting.
Well, I think part of the explanation of INEC was that on that day of election, they had thousands of cyber attacks. So people were trying to breach their server. Yeah.
That excuse is so dumb that I'm even ashamed for INEC. Do you know how many attacks Amazon receives a day? Do you know how many attacks Nigerian banks go through a day? Have they shut down the operation because somebody is trying to hack them? What is the purpose of firewall?
Maybe it was not strong enough to withstand the attack.
They invested so much money.
Okay.
The problem is that we live in a country where people are not held to account for things. And that's why people are not afraid to repeat these things.
To bolster what's about country say, this same Nigeria, when JAM fully come to CBT during Debo during
this time,
they say someone was trying to hack when the election exam was going on. Someone was trying to hack the JAM. They arrested that guy at Atiku here. You get my point?
I'm with you.
INEC supposed to plan for this in case of anything, but there are some areas that we are nobody is even looking at. So why is it? What can we do so that whenever we want to conduct any election, all the security agencies will promise us that
that will take us
to on ground, that nothing will happen. When something happens, we are not calling them for any question at all.
I will tell you something. I think even when we talk about judgment coming from courts, there are critical areas that we can also solve our problems from. In the first place, if we conduct an election that is acceptable to most of the candidates and the people,
right, so just hold
we won't even go to.
Okay, so let's talk about electoral reforms now. It's still Political Roundtable Mainland 98.3 FM. We're looking at the judgment of the Presidential Elections Petitions Court as delivered. The Labour Party, Mr. Peter Obi, the candidate, have said, look, they don't consider it as delivering justice, and that they will be going to the apex court to seek redress, to get justice. Alhaji Atiku Abubakar, in a well-organized press conference with the party, with the PDP, have also said that, look, they respect the decisions of the justice of the appeal court, but they will be proceeding to the appeal court. But we've looked at the major parts of the judgment, and like Barrister Curtis have said, if lawyers cannot all agree to say whether the judgment was proper or not, then what should then be? What can we do as journalists or ordinary people? So if the platforms of lawyers is still on fire as far as that judgment is concerned,
the law is like an elephant.
Yes,
you describe it based on where you see it.
So it's perception too, right?
Now and then, like we said, those who are supposed to sit over the arguments of lawyers have the right to attach weight.
at their own discretion.
And they can decide not to attach any weight by going technical. I say we don't even want to look at the merit of the case.
But you know, there's this issue of substantial compliance.
Substantial justice.
You know,
no,
in this case, in an election, yes. Well, look, you can't have it 100%.
No, I think this is the test. If you are alleging rigging,
yes,
which is a criminal offense, you have to prove beyond reasonable
doubt. Yes.
Now, if you are alleging other forms of irregularities that do not amount to rigging, the test then becomes
substantial compliance.
The conduct substantial with the existing extant laws, or is it so fundamentally flawed?
So, if, for example, you say you have 3 guidelines to declaring results,
yes,
and 2 was met, so 1 failed,
the test
can it nullify the election?
The test is not perfection.
Okay.
It's substantial compliance.
Which the judges have also said in this case, the justices have said in this case.
Yeah, that's what I'm saying. Look, having formed the opinion that the petitioners couldn't prove rigging, okay, and couldn't prove that this was where the crime.
So the issue of substantial compliance became a problem.
Yes, so it means that there was nothing before the justices to show that the election was flawed.
Okay.
And that's why they said, oh, we're looking at substantial compliance with extant law. And in our view, it's our conclusion that INEC complies substantially in the conduct of the election with the existing rules.
All right.
So that's how they arrive at that.
All right. It's still Political Roundtable, mainland 98.3 FM. We're streaming the show live on Facebook. So I can see that there are a lot of comments dropping on the Facebook platform already. It's a bit heated. And I think I want to just tell our listeners to calm down. So please take a chill. I'm not heated, really. But, you know, I just want to appeal to all our listeners and those on Facebook who are already dropping comments to, you know, be a bit civil in their choice of words. I can see that.
I want to appeal to
people are agitated already.
I want to appeal to all Nigerians. Usually politics is very hot. It's a hot issue. But politics is supposed to be a battle of ideas.
Ideas, yes.
And so we may disagree with one another, but essentially we have a country to nurture.
Yes.
And so even if the Supreme Court upholds the judgment of the Court of Appeal, I would like to appeal to everyone.
We have to move on with it.
This is our country. It's only a matter of 4 years. I mean, and then
we have another election.
Opportunity.
The 4 years is the issue now. You know, the Supreme Court will deliver its judgment. But like Eboade has said, I'm going to try and read out again what he said about us now going into a period of sober reflection, going into our electoral process, reorganizing INEC and the entire electoral process before we go into another vicious cycle of failed elections in 2027.
That's almost impossible.
Yes.
And I'll tell you why.
I'm going to come. But again,
it's impossible because those who conducted the election don't even see anything wrong with the election.
No, but Mr. Curtis, those that conducted the election may not have seen anything wrong in the conduct of the election. But the question I'm asking,
the beneficiary also don't see anything wrong with it.
No, this is the question. This is the question, Mr. Curtis. Now, let us assume that the Supreme Court upholds the verdict of the appeal court on all of these petitions. This is not the first time. We've said it that from 1999 till date, we've conducted several elections, presidential elections, and not any of them has been nullified by the Supreme Court. And so what happens is that, look, the Supreme Court gives its judgment.
They came close, 4-3.
4-3, fine. But none has happened, even though we've seen dissenting judgments and all of that. But we got into a point where in 2007, the late President Mᴜsɪᴄ Yar'Adua admitted for the first time that, look, the election that brought me in, may we never see an election like that again in the country. And because of his good intentions to ensure that, look, going forward, the electoral process becomes better, decided to set up a 22-man committee led by former Chief Justice Muhammad Uwais. And they worked for 1 year. In December 2008, a committee report of over 300 pages was submitted to the president that highlighted all of these things we are talking about, Mr. Curtis. It's not new. That's the funny thing. All of the issues that we are talking about now, it's not anything new to our electoral process. No, the idea of, for example, how to make INEC more independent. The INEC financing, the appointment of the chairman and the board members, everything had been well, talked about in the 2008 committee report. Also, the issue of, dispensing with election matters before swearing in. That was also an issue this time around. That, look, can we have a situation where elections are concluded, litigations are concluded before we swear in governors and presidents?
We saw that in Kenya.
It happened in Kenya.
Yeah.
Their presidential elections was
Constitutional Court.
So again, we had that recommendation since 2008, and so many other recommendations as independent candidature, election financing, the roles of the security operatives, how to make INEC more independent in terms of funds, in terms of the appointment of the chairman and the board members, their tenure, the role of the NJC in appointment of chairman and the board members, and even the Senate in terms of so many things to make INEC more independent. This is my question, Barrister Curtis. We have another 4 years now. Are we going to see a repeat where the Supreme Court gives judgment again? All politicians sit back, issue statements to disagree or agree with the judgment of the Supreme Court, and wait for another 4 years to go into an election that has all of these lacunas in our laws, all of these loopholes that would most likely also give us an election where we are still talking about these issues. There are people who have said that the reason why politicians are quiet is that they also want to be a beneficiary of a flawed system. So they keep quiet, hoping that, look, for example, if I become president, I also want to be the one appointing INEC chairman and taking advantage of the process. You think it is still as a result of the selfishness of our politicians that we have this problem?
Why nothing will happen in the next 4 years? The president who conducted the election gave himself a pass mark. Former President Buhari. I hope you know that.
Yes.
In fact, he was in France somewhere defending the results. Okay? And the beneficiary, the current president, also does not believe there's anything wrong with the conduct of election. Right. An election that he lost his own base. Do you understand? And many of his supporters don't believe that anything untoward happened. So you can't, where you don't carry a solution in search of a problem. Okay? You have a problem, then you look for a solution. In this case, what people are doing is telling the man to carry a solution and look for problem. That's not going to happen because in the first place, he doesn't even believe there's anything wrong.
The problem, yes.
But having said that, I think that it raises a bigger issue, and that is the issue of attitude. The attitude of the typical Nigerian citizen, public officials or individual. Is he willing to live for causes that are greater than himself? We saw that in the life of President Yar'Adua.
Yar'Adua, yes.
Yar'Adua was the ultimate beneficiary of
a flawed election, and he admitted it.
And he said he was willing to abide by anything the Supreme Court will say. But when the court said that Atiku could not discharge the burden on him,
burden of proof,
for proof, and upheld that
the
election.
same problem we are talking about now.
Yes. Yar'Adua then decided to set up that committee to reform.
That even though they could not prove the allegations, but something is wrong, and he admitted it.
But there's a need to go beyond the now and take a long view of the future.
Which was what he did.
And that was what they did. Now look at what happened in the United States in 2000. When 437 votes in Florida determined that election. But that election went as far as to the U.S. Supreme Court, the litigation. And the U.S. Supreme Court said there must be an end to litigation and took the matter back to Florida. Gore issued a statement. He said, I don't agree with the judgment, but I accept it in the interest of the United States. Now, what has happened after that? What led to that case? I don't know if you remember, it's called Chad. Now, when you take a ballot paper, and you punch it, the paper either detaches completely from it, or is hanging, or is depressed, but was not detached at all. So there was the argument whether a dimpled Chad or a hanging Chad should be counted
as a valid vote
or not. Now, as a result of that, in Florida, they have moved forward
to address that issue.
And
resolve it.
This is the problem in the country is that whenever we have a problem on ground, the desire to solve that problem is not there if I'm the one benefiting from it.
We just keep quiet.
It becomes a problem when I'm the one at the receiving end. I will highlight it.
And talk about it.
I will highlight it and use it and get into power. But once I get into power...
And it benefits me.
I
keep quiet on it.
I'll keep quiet about it. Look at what the former governor of Ekiti said in the course of the week.
That they played politics with...
subsidy
removal in 2012. Yeah, he said.
Yes. So we all know that one of the biggest problem that INEC has got is funding.
Is independence.
Before you even talk about appointment, okay. And because when you don't have that power over funding, you can't be independent. And I will tell you a story told by the former governor of Cross River State, Donald Duke. I don't know if you still remember what he said, how elections are rigged at the state level. Now, he said when an INEC commissioner is posted to a state, he comes to that state without anything.
He's just coming.
So he goes to the governor and says,
I'm here, I'm the new rec.
I'm here, I'm the state new rec, and they have brought me here. So he said in his case, he called his chief of staff and said, we have our friend here, put him in a hotel first.
To just calm down, settle down.
Give him accommodation, an official car, and help him to settle and order.
And the rigging has started.
And then the man comes back and says, oh, Your Excellency, thank you so much for order.
For being so magnanimous and so.
Your Excellency, we are about to hire people to conduct the election.
You have people, volunteers?
You have lists. He said, oh, no, don't worry. The state chairman will contact you. And then the state chairman will go to the rec with names of party members in different local governments who are then appointed to conduct the election. Say, tell me, how can that election be free and fair? Because they are all agents of a political party. That's why the Uwais committee recommended that INEC funding should be on the first charge.
Yes, it should be as from their federal allocation.
Yes,
like any other money.
Now, why are they also talking about the appointment? Because you see, if the president can appoint, if he can hire, he can fire.
Fire, definitely.
No matter the constitutional protection.
He's the one that is hiring.
The CBN governor has secure tenure.
He's been suspended now.
He's been suspended.
Even though he was supposed to go to the Senate.
He has been suspended. Because the president has not gone to the Senate to ask for
his removal. But he's suspended. So it could even happen to an INEC chairman.
Exactly. So
on trumped up charges.
Look, and the whole idea about democracy is about the guardrails. Those systems, the bulwarks that protect people while they are doing their jobs, the rights of individuals. And this, not only in Nigeria, in Africa, these things don't exist. You know, I just talked about how you complain about the system, but once you become the beneficiary, you keep quiet.
President Muhammadu Buhari was in court 3 times before eventually won. Look, challenging the system, challenging the electoral process.
Can you see what is going on in Côte d'Ivoire? You recall that when President Boigny died,
yes,
there was a conflict on who succeeds him between Konan Heni Bedi, the then speaker, and then the Prime Minister Alassane Ouattara, who is now the president. When Konan Bedi wanted to conduct election, after he succeeded the president, he said Alassane Ouattara's father was from Burkina Faso. So he amended the constitution and said he cannot contest
because his father is from Burkina
Faso. Then there was a military coup that brought in General Robert Gay. Robert Gay disqualified Alassane Ouattara and brought in only Laurent Gbagbo,
who eventually became and defeated him.
The people voted for Gbagbo. Gbagbo became president. Gbagbo lost an election to Alassane Ouattara and didn't want to leave. And he had to be dragged out of the house. The same Alassane Ouattara now is now president.
And he's not addressing those issues.
He's amending the constitution to run for 3rd term. But this was the guy who worked in IMF
with all of his exposure, knowledge, and education,
and kept talking about
reforms
of electoral process. He's amending the constitution now to run for 3rd term. That's how Africans respond to
So, Barrister Curtis, why is it that there's no commitment? You know, for example, you look at Alhaji Atiku Abubakar, for example, who has been running.
Look, and been fighting.
And they are fighting the process.
Fighting for electoral transparency.
But I have not seen a situation where, for example, he has made it an agenda for his party members to say, look, we are not running for any other election until these things are fixed. Let's reform the electoral process. So he keeps quiet, talks about it like you said. Another election comes in, he participates, he loses, he goes to court.
Because he doesn't have let me tell you, he doesn't have the power to reform the system.
But what of push an agenda to reform it?
He's been doing that in his private capacity. But let me tell you something. There's a say in America that there is no democracy in political parties. There's only democracy between political parties. What do they mean? In the conduct of election, the political parties will insist that there should be democracy.
That's what they say.
But in the conduct of their own affairs, there's no democracy.
You see in position.
The party leaders decide who they want to put in.
But what I'm saying is that, look, if politicians cannot play by the rules, can we have a situation, for example, where the law forces them, Joseph Folonshaw, to play by the rules? Because we have seen it that it's extremely difficult for politicians to play by the rules.
It is possible, but then you have to find, you see, institutions cannot defend themselves. Institutions are to be defended by individuals.
You know, there's an argument
who are protected and courageous by the system.
So the argument is this. Yes, we keep talking about selfless Nigerians who see the nation above personal gains and all of that. But there are people who have said that, look, yes, you expect people to build a nation, but you can also have a situation where the institution, the system they are talking about, forces the people to want to work and build the nation. Can we have that as far as the elections are concerned in the country?
Let me tell you, and that leads also to the argument. How do you build a system? What we have seen all over the world, okay, is that systems were built by dictators, benevolent dictators, either as civilians or military men.
Inserting a legacy.
Yes. First of all, you see, when you build a system, and then the system can take off from there and begins to protect itself and every other person. You saw what happened in Singapore, Lee Kuan Yew. It was like, he was winning election, but he was a dictator. He didn't give a damn what anybody said. You understand what I'm saying? Now, if you go to UAE today, with all the admiration and the things we
it's
talk
still a
about
dictatorship.
There,
it's still a dictatorship. It's just a one-man show.
In fact, this kind of democracy we practice in Africa is not for Africans. Do you understand what I'm saying? Now we've had missed opportunities. You see, I've said to people before in the past, and this is my personal opinion, if former President Obasanjo,
with all of this in 1999,
when he became president, then there was nothing standing on his way.
The politicians were not this.
If it wasn't for the third term agenda that he became confused with, he started the EFCC.
Yes.
He started some ICPC.
So many reforms.
He would have been able to build this institution.
Strong electoral process for us.
Forces. But again, it's human. He has denied that he never asked for third term.
Even though we know what happened.
Maybe his friends and associates did. But what is important is that we will need a leader. You understand?
Yes.
There was one leader in Africa that I thought was in the mode of Mandela, as the current president of Senegal, Macky Sall. Macky Sall was the one that led the senators to agree to disband because Senegal didn't have enough money to keep the two houses. So the way to make progress, right, is to have leaders who are committed to building their country, even at their own expense. Do you understand? We had people like Azikiwe, Awolowo in the past. These guys let them look. They did everything to improve their part of the country, even though you not look at them and say, "Oh, this was a national leader." What Awolowo did in the Southwest, all the governors and everybody put together since 1999.
I've not done half of it. It's not even a quarter.
How much money did he have
at that time?
At that time, when you go to the states, what Ambrose Ali accomplished in Bendel State,
the old Bendel State,
put all the governors from
Igbenidion to
what have they achieved? Go to Benue, what Aperaku did. Go to Ogun State, Onabanjo.
Onabanjo, yeah.
Go to Ondo State,
yeah.
Ajasin.
Even Bola Ige, your state.
Yeah, you understand? I don't want to mention one state now because I don't want any problem.
Jack Conde in Lagos, don't let us waste time. It's very yes.
I think there's a big challenge.
Can we reform the electoral process?
We can. It's not impossible.
So, but nobody's committing to it.
Now, the reason why it's difficult now,
nobody's committing to it.
You see, the thing is that look, reforming the electoral process should be a constant thing. Because you see, every system
evolves,
and then it gets to a point because the human society is progressive and very dynamic. So as you go along, you see right now in America, they are changing voting machines.
Making it better, making it,
that can easily be hacked.
They improve on it,
Let me tell you something that America has gone so far in election conduct that as soon as they finish voting, you have what is called the exit poll.
Showing the tallies.
How the people would have voted. Why? Because the issues the issues are graded. Oh, you voted for what reason? Oh, I voted because of.
So there's even a guide to what the outcome could be.
I voted for.
You know, Okafor, to me, why some of this reform will be difficult is there are some fundamental things that we must do, and one of it is, let's go back to the basis. If at the national level, supposed to be, let's even go back to the governor. Let the governor reform the state electoral body. If there's any election, because we can't do without. If we are serious, we understand it.
Which state conducted election last week and the party won all
those states. PDP won everything.
So now,
even the councillors,
18 over 0.
everything.
Now, see, forward.
Yes,
the governor cannot sit down and say, you know what, we need reform. But
no, you know why the governor, just like Mr. said, you know why the governors are not even thinking of reforming the state INEC structure? Is that they are beneficiaries of that WAP.
Because there's no commitment. Now, do you know that?
What commitment?
No, what I'm saying is in every system, if we must do something that is okay, systemic, and on due process, this program is 2 hours, right? And it is stated there. We have a rundown. You stated a 2 hour, no matter whether we finish or we not finish, it must end. But in Nigeria, immediately you put us 2 hours, we'll not be, it's going to 8 o'clock. What do we do to manipulate?
To play and make it to 4 hours or 3 hours.
Any system that permit that, don't know that we are not ready for any reform.
Look at what happened in
Adamawa.
In Adamawa State, yes.
In Adamawa State. Look at what happened. Where the state resident electoral commission
was declaring results
before
elections were concluded,
because he said he felt that the returning officer of the state was compromised. That's what he said, and so he decided to
on his own
outside the procedure and the rules, accompanied by
security forces
agents to announce the results. Now, has anything happened to him?
Nothing.
Apart from the fact that INEC suspended him, and then the governor, of course, who would have been the victim of that process, Umafintiri, promised to prosecute him. Not INEC.
No, Oga Curtis. I may not even have issue with the electoral body, but me, I was suggesting in another forum that if Nigeria is system, one, they would have fired the CP, the CP, the DSS, those who actually, because without those people, only that man cannot see.
But Mr. Curtis, again, just to buttress what I'm saying, local government elections conducted after so many years. PDP has taken 18 of all the local.
I said in Benue they disqualified all the opposition candidates.
Now, in that same election in Edo State, the APC has complained, and I've said, look, it was a rigged process. But when Oshiomhole was there, Jᴏɪᴜ,
he did the same thing.
He did the same thing. Allowed, no complaint,
we
nothing.
Are back to the point that I made.
So now PDP is there, APC is complaining.
It's just like the case of corruption in Nigeria.
Yes.
It's only corruption when people don't benefit from it. We love corruption in this country. Don't let anybody deceive you. When they are the ones benefiting from it,
it's okay.
It's not corruption.
It is blessing. You know, God is blessing them, and they are happy with it. Now it becomes corruption only when they are not the beneficiaries. Do you understand? And that's why the corruption in Nigeria is turn by turn. So somebody complains about an electoral system that disadvantaged him. Okay,
and
he gets into the system
and keeps quiet about it.
He keeps quiet about it because now he can take advantage
of that same problem.
Let me tell you, there was a story that I was told about the former president.
Which of them?
Well, let me not mention it.
Okay.
But he had boasted so much about reforming the country.
Yes.
How he was going to water down the power of the president. He was going to give more powers to the state and practice true federalism, according as they call it. They said then when he resumed at Aso Rock, he said, wow, the power here is so enormous that if I give anyone away, these governors will mess me up. And so he enjoyed the power to the maximum, treating governors like they were his houseboys. But the same man going about complaining today, the power of the Nigerian president is so enormous. There's a need to water that power down and give more roles to the state to play. Now, that is the argument that the governors love.
Because it favors them.
But then when you go to the state, Governors don't give any power away at all to the local government.
They are even taking part of the powers given to them.
In fact, what they will tell you, they talk about true federalism. They will say that in a true federal system, local government should not be a constituent or an existing level of government. But you see, they also do not think that in a federal system, states don't go to Abuja to share money. States generate their income.
Income, yes.
And when they need to pay taxes to the federal government, they pay taxes.
The center pulse, yes.
So you see the hypocrisy in our system. And that is because nobody actually wants to live for the country. Nobody wants to see the country make more progress than themselves.
You see, by psychosis, because we are going to open the phone lines.
Take us back that what is Nigeria interest?
No.
You know, last year, was it last year, by psychosis, the case between Federal Inland Revenue versus Wiki and some other, what's the end of the host? People, let's
see again.
Let the states.
We don't litigate anything. Look at the issue of look at the issue of budget.
Yes.
This year, the president will submit a budget to the National Assembly. The National Assembly will take the liberty to alter that budget the way they want to do it.
The
government will disagree. But we have never gone to the court to test that power.
Can the National Assembly?
Because this is how
alter budget figures.
You build a system. Do you understand? That is it the exclusive power of the executive? Because you see, the legislature control the purse. But the executive that spends the money
is supposed to
and who control the economic policies are the one who decides how much they want to spend.
So should the legislature now tinker with figures, add and remove?
But once the budget goes, these guys will take the money and do whatever they want and
move it around.
Around. Nobody has gone to court to challenge that, to say, look, what should be happening in this kind of
No, by psychosis, because I want to open the phone lines. So we have a lot of messages on our Facebook platform. It's still Political Roundtable, mainland 98.3 FM. We have Barrister Curtis Adigba with us in the studio. Joseph Folorunshò is also here. And we're looking at the judgment of the PEPC, that's the Presidential Elections Petition Court. Again, it's not the end. The Supreme Court would have a final say on all of these petitions. But
just calm down.
I think people should calm down. I can see that people are already challenging by Mr. Curtis, but we are going to get there. But honestly, I'm looking at us moving forward. We are not politicians here. We understand that, look, they may not really commit to this thing, because you ask yourself, Yar'Adua died, Goodluck Jonathan came in. Who had worked with Yar'Adua, who was vice president when the Uwais committee report was submitted? He knew why that committee was set up, and for 6 years as president, he never touched it.
Well, I think I'm not here to defend him. He came in and then he wanted to pass that through the constitutional conference that he called. If you recall, they also dealt with the issue of
of course, independence.
Yes, but of course, it was not implemented.
Okay, then again, we had the Buhari that ruled for 8 years. I think sometime in 2017 or so, he also set up a committee to look into that report and come up with a framework to implement what had been said. But I think the best that we got from the Buhari government was the amendment of the Electoral Act 2022, which only touched a few.
Which was not his own initiative. Which was championed by the opposition and
yes.
the civil society.
And what we saw was just 1 or 2 areas.
And I can tell you that would not have passed if the then Senate President Bukola Saraki was not in opposition to the president,
who allowed a lot of those things to scale through. So again,
but again,
yes.
well, if you go deep into setting up a committee, committee is usually a sign of failure. You understand? Because you're supposed to do a particular thing, because you did not do it, and something happened. You now say, okay, instead of you to probe that system, the people that were they negligent, who did not do what, and who do what, we now say, let's set up a committee to now maybe ease those people, forgive those people, and the rest of. I think it is time. It is time for Nigeria to sit down and say, okay, if someone's supposed to do something, which the lawyer will call out, it can be out of omission or commission. I did not do a particular. I'm supposed to do a particular. I did not do it, and something bad happened. I should face the consequence of that. Not for you to now set up a committee and now forget about what the role are supposed to play, and I did not play that thing. We'll continue to set up. State are setting on committee. Local government chairman are setting on committee. Abuja is setting on committee. At the end of the day, we have endless
committees and nothing happening.
and nothing happen. Why not? I will subscribe that. Let us allow the rule of the law to only take place.
Okay, well, I'll ask a final question before the phone lines by Mr. Curtis Adigba. Do you think this government, as led by Asiwaju Bola Ahmed Tinubu, this APC government, who has succeeded in having a very friendly National Assembly, whether we like it or not, everything seems to be scaling through easily. So one will think that, look, whatever reforms he wants for the polity, will really scale through because of the kind of arrangement we have now. We have, I think, a more friendly, more balanced, more, cordial relationship between the executive and the legislature. Now, do you think that this is time for the president to look at this Uwais report, or set up a proper framework to ensure that, look, in the next 4 years, we don't have this same problem coming out from our elections in Nigeria? Or do you see a situation where it's going to be the same of the old same? I'm a beneficiary of a flawed system. I allow it to endure. It comes again. I benefit from it. The same story continues. Is that what you see going forward?
I think the problem is your characterization of what happened and its perception. This president does not have any incentive
to change anything.
And I'll tell you why. One, if he says, oh, the election that brought me in was flawed in some ways, okay, and let us change or tweak the system
to make it better so that it doesn't repeat itself.
People will say he didn't win the election.
Okay, so it's not, or maybe he has it in mind. He doesn't want to say because the election is
the only way he will have the incentive to go ahead and reform the system further is to make the argument that as good as this system is, it's still not perfect and it's still not responding to the wishes of Nigerians the way it should be. Because we can have elections that are rank-free. We can have elections that we don't even need to go to court. The outcome will be so clear to everyone that nobody wants to challenge that result. Do you understand?
I'm with you.
Now, so the only incentive we will have is that which says, I want to live above my own personal interests. I want to go beyond and above for the interests of the country. Yes, the system, the election that produced me is good, but it's not good enough. I think we can do better.
Okay.
If he has that mindset, then he might want to embark on more reforms. But if his intention is, okay, I'm here, I've been declared the winner, the courts have upheld my election, I'm going to use the same system and win another term. And thereafter, somebody else can take over. Then he will be reluctant about doing so. But I'm urging him personally
to reform the system.
To reform the system further.
Joseph Olohunshor, 1 minute. Do you think this president can commit to electoral reforms? Body language, his thinking, the people around him, are you seeing anything that shows that they may? I'm just saying, put everything together. Do you see the government going towards the direction of reforming the system?
Well, I doubt. The reason is simple. President Bola Tinubu is now in Abuja. But if you look at the way things are going, you know that there are a lot of other
factors
that will say, okay, no, but you go change this thing. Let's talk about 2027. 2027. And again, it's difficult for any president in Nigeria to succeed without the backing of the governor in that particular thing. You know, Barrister Curtis, immediately the man sworn in, there was a group that just took class 1999. Led by former governor. Led by my former governor. Assuming these people are people who have succeeded in their tenure, you can say, oh, because they want to maybe push something, these are the idea that make them to succeed in their various states. But they went there, and it's only God that know what they conclude, what is going to happen to every one of us.
So you don't think that there can be commitment to electoral reforms?
It's going to be very, very
all right. So 09136000410.
And the losers today who are crying,
if they get
there, they will not reform.
So that means we can't make we can't make any progress. All right. 09136000410. 09136000410. Still Political Roundtable, Mainland 98.3 FM. We have two issues on the table, but almost like the same issue. The results of the PEPC judgment, the reactions. The lawyers are not even agreeing. We've seen different comments from different lawyers giving different interpretations, agreeing and disagreeing with the judgment of the Presidential Elections Petition Court. And so it's not anything new that we have divergent opinions as far as that judgment is concerned. So let's hear your own opinion. What do you think about the judgment? And do you think that it's time for us to reform our electoral process so that in 2027 we are not bedeviled again with these problems of manipulation, independence of INEC, IREV or no IREV, electronic transmission of results, 25% in Abuja and all of that. 09136 0000410. Hello, good evening. Hello, good evening. Hello. Hello, good evening.
Good evening to you, all my family in the studio.
Good evening, Prince Wise.
Good evening to all of you. Yeah, number one, I want to challenge Barrister Faje.
Just give your opinion, Prince Wise.
That's why
it's your time to talk.
I agree with your lawyer Faje.
Okay, so give your opinion.
I agree it's allowing. Now, the party, you have 170-something thousand polling booths in the whole country.
Yes.
And the one that's making us have only 130,000. What are the remaining thousand who don't have an agent? And during the you are taking your matter to the court. You have no one witness among your polling agents. That is the one that got his own polling. You see 18,000. They treated you. And before uploading to this area we are talking about, your agent might have gotten their own ECA form. Back at it, upload all that one to the Election Tribunal. That this area, this state, even though you can't prove for, back at prove only 2 or 3 states that they treated you. That's number one. Number two, we are talking of Abuja. If you make slap on the face of Nigeria, if they now allow Abuja to take better status for what? They were telling Nigeria, Abuja is a federal territory. But if you get 24 from other states, plus Abuja, you get 25 there, you won in Nigeria. Now, if somebody wins 36 states in Nigeria today, or 35, I pray to win Abuja, will tell me that man is not ready to be president of Nigeria. We are not taking us to America. Let me tell you, what is very clear. This judgment today, I want them to replace that judgment to put it in video so that we can buy it. Comprehensive judgment. Those judges, they are more, in fact, I thank you.
All right,
some of us, please let me add up.
Okay.
Some of us, not a lawyer, are better than some lawyer today that defend the loser. All right. Because they not put their key.
Thank you, Prince Wise. Thank you, Prince Wise. You spent over 3 minutes. Hello, good evening.
Gentlemen in the studio.
Yeah, good evening.
My name is Peter from Bucknor.
Okay, Mr. Peter, please go on.
I just have something to ask. I've been seeing trending on social media the report by the 5-man judges.
Justice
that is a copy of what APC prepared. I don't know how true. I stand to be corrected. At the heading is there that is Tinubu's own.
You see, there have been a lot. There's a lot of Mr. Peter. There's a lot of misinformation out there. We've seen lawyers saying, "Oh, there is a copy that has the APC copy on it and all of that." Whatever it is, the judgment is the judgment, and I think we should just talk on the judgment.
I think the issue also was that when the judgment was given,
yes,
the petitioners had asked the court for CTC
immediately
because they have 14 days, including weekends, to go and appeal.
Yes,
and they found out that the copy that was made available, the first was made available to the respondent. Yes, and that it has a heading.
So maybe the copy of the respondent, and yes. but again, I'm just saying that.
But I think it's just for me. I don't know how critical that is. They should just go on appeal.
The judgment is the judgment. You have 21 days appeal, and let's take it from there. Hello, good evening.
Okay, the second one, sir, is that we know the Constitution says 25% Abuja is needed. How could judges decide that Abuja is no longer necessary?
No, according to the justices of the appeal court, what they are saying is that, look, it is not needed because there's no special status. We have to wait for the Supreme Court to either agree or disagree with the wisdom of the justice of the appeal court. So we have to wait.
Okay, my take to Nigerians is that the 5 judges have murdered democracy in Nigeria.
We can't. Again, you see, that's the beauty of democracy. And like Barrister Curtis said, that's why we have different levels of seeking
in the appellate system,
yes,
the judicial system.
You can appeal if you are not satisfied. Yeah.
People, you can feel very hot about this, but the truth is that the court of law is not a court of sentiments
and emotions.
And emotions. You have to go there and prove your case. And if the justices,
in their own wisdom,
felt that the petitioners couldn't discharge that burden, and there is a need for them to go on appeal, let them go on appeal. So,
and by Sarkozy, like I've said on different platforms too, all of the petitioners, incidentally, have been beneficiaries
of the same system.
Mr. Peter Obi in the past was restated as a governor.
What about Atiku?
Obasanjo
literally sacked him as vice
but
president.
The court kept keeping him there. So, and that was why, even in their disagreement of the appeal court judgment, they kept saying that, look, they respect the wisdom of the justices.
Atiku was very nuanced.
And that, they believed in the judiciary, and that, look, they have the right now to go to the apex court, to seek redress. So I think we should buy that idea and not cast aspersions on the personality of the judiciary. We have no other option, really. 09136 0000410. I'm going to take all of the messages on Facebook, but let's take more calls. Hello, good evening.
Yeah, good evening.
Good evening, sir.
Yeah, my name is Lukman. I'm calling from Akute.
Lukman, please go on.
Yeah, I want to react to the judgment.
Yes, please. Please go on. Please go on.
Okay. It's unfortunate that in Nigeria, we only have lawyers who understand.
Can you reduce the volume of your radio set or turn it off completely? We're having this feedback.
Okay. Is it okay?
No, we're still getting it.
All right. I'm moving from. So we have lawyers in Nigeria who are very sure that the case they are pursuing is not genuine. We just to waste the time of the court, and they will still go ahead.
Is that what you think?
Yeah, of course. Because when they came up with the issue, I don't even like APC. I'm not their supporter. But when people fly unnecessary, sentiment, and their followers too can hear the last caller the way he speaks, you know that you know where he belongs. You understand? I am not an APC member. But, the opposite looks as if they wasted the people's time, raised their hope as if something
will happen.
Will happen. But just as you said, even law is a product of logic. You understand? You cannot argue that Abuja should be given one special status. It doesn't even make sense anywhere. If Abuja is the biggest state in Nigeria in terms of population or even land or anything.
Again, Lukman. As much as the argument goes to, why should the Abuja people have special status? If you listen to our conversation, there are countries where states are giving special status. You may want to also.
It doesn't exist in Nigeria.
According to your own interpretation, who knows whether the framers of the Constitution thought that way, that there should be special status for people within that territory. But again,
let me even ask you: if the first condition, which says that you have to win simple majority of votes and a quarter of votes in at least 36 states, if someone had won a simple majority and did not meet the other condition, would you swear him in as president?
No, the constitution is the constitution.
Okay, and then when the same constitution said, after talking about 2/3 of the state, and then say, and Abuja.
But by Sarkozy, you lawyers will kill us. We're trying to interpret simple grammar.
That clause and Abuja means that you cannot.
So why did you?
You cannot neglect the people of Abuja because.
So why did you? Exactly.
No. What Lukman is saying is that, look, in the 36 states, because they are part of Nigeria, you cannot neglect them. Doesn't mean that it is compulsory to have to be in Abuja.
What the constitution should have said, including Abuja.
So that means the framers of the constitution.
That's what I'm saying.
Okay, so we'll have to wait.
That language is changed. You cannot just say that.
All right. Thank you so much, Lukman, for the call. Yeah, thank you. God bless you. 09136 00004. Hello, good evening.
Good evening.
Yes, your name.
Okangbilina from Mafuluku.
Okay, Mr. Okangbilina.
I've listened to all the people that gave judgment that day. I listened to it. It was very boring and some people were sleeping. But what I feel should be done, like Barrister Curtis was saying, is that we need reform, especially in the electoral process.
Okay.
If they will do it, is the question. But me, if you talk now, they will say 180 days is too small for because I want it's left to me. The president should not be sworn in before they finish the court litigation. If they want to conduct election, it should be 1 full year. They should conduct election 1 full year before they swear in the new president. That with that 1 year, they can resolve all the litigation.
So, Mr. Kamula, your own is reforms. We should reform the electoral process.
Yes, so that if they conduct this election 1 year before the new person will come in, you will not have authority. Look at now. The president who decides everything, make all appointments, has the money, and he can look at how the judges, the people were talking that they were just talking as if they were shouting at it. And I know that if another president was there, even if it's not this one, they would have still used this technicalities to favor that person.
Okay.
That's how it is. So we need to find out. So we need to get this thing right. Let the president not be in power while the litigation is going on. That's what should happen.
All right. Thank you, Mr. Kamula.
Even if the speaker that was there when this, they would have still used big grammar to put him back there.
It's true.
So anybody would have benefited from this system.
What is saying,
yes, anybody would have benefited from it. So we should not allow president to be sitting there while this will be going on.
So Mr. Kamula, what you are saying is that we can't go into this again in the next 4 years. We should change it.
Okay. I didn't hear you.
I said we cannot do this again in the next 4 years. That's what you are saying. We should not repeat this.
Look, if they can do the reform, right? But the question again is that who is going to do it? Is it these people who are benefited from it?
Okay, all right.
They cannot do it.
Thank you,
because the two will remain like this.
Thank you, Mr. Kambilina.
There was the argument as to whether we should allow the governors and the president to be sworn in before the cases will come up in court.
Or we should conclude with the cases before.
Don't forget that from 1999 up until date, that has been the practice.
And the lefty, nobody is changing anything.
Yes, but you see, when people are not yet in their offices, there's less pressure on the judges.
Of course, I agree.
Yes, and because you see, like the case of the president, he now controls the judiciary. He controls the forces, the armed forces. He controls everything. Do you understand? So, and because he's already in office, and the governors are already in their offices, it's difficult.
So you also agree with this?
I agree.
The Uwais report that look, if I always said 6 months is enough.
Let me tell
before you know, and then we'll conclude these cases.
You know, it was in this studio that I said this whole attitude of going to the Court of Appeal before going to the Supreme Court, as far as presidential election
it could just be Supreme Court alone.
It's just a waste of time.
I think Kenya does Supreme Court straight.
Yes,
it's just the Supreme Court.
It's just called the Constitutional Court. These issues that the petitioners raise should have been, Supreme Court could have had the original jurisdiction on this matter and dispense with it in less than 50 days.
I've seen lawyers who said within 2 months all of this would have been sorted out, really.
So there's no need for all this. I mean, as far as the
180 days, yes.
Some of this thing will know it will not happen, the reform will not happen, except to again we check it that the governor and the president should not be having free or uninhibited access to our purse.
We do say that
because if you give that that you are working in a company, you can decide to take money from the fund
and put it wherever you want.
Now say someone is going to reform that thing. You will see that.
We'll talk about that because that's talking about reforms again in terms of governance in the country. That's a very big one. But let's take the messages we have on our Facebook platform. We have Benson Richie. We're saying, good evening, my great wise men in the studio. Mr. Obiora is a chuku. Well, we have your message here, but the tone, the tone is.
If it's not
the tone is a bit inciting and not fit for radio. And then we have Mr. Lelekhon, who is supposed to join us in the studio. Talk somewhere. I think, like I said, he's listening. He's also taking him up on that particular statement. I think we should just accommodate one another. It's just one Nigeria.
It's not life Let's just death. So somebody must be president per time.
So we have Basil Chika, who is saying there are a lot of loopholes in the presidential verdict. If they said FCT is not different from any other state, why can't somebody become FCT minister and go back to his state and be a governor, vice versa? Bala Muhammad of Bauchi, Rufa of Kaduna State, and recent Wike. So you find out that these judges continue to diminish our law, and it will surely come back to on them because you can't idolize forever. That's Chika Bende from Trade Fair. We have Oní Ọlálékan saying the law is clear. The electorate is clear. Sentiments, emotions is what is disturbing a lot of people. We have Dayo Dada who is saying, good evening, crew. One can see that this judgment is well. Again, Dayo Dada, this is radio. We can't read some of these things out, you know. We have somebody who is still being starting trial for putting up a publication that the former minister wrote the judgment for the Court of Appeal. And, you know, this is like the same message you are getting from you, please. Let's leave. All right. So let's, we have, you know, you can always comment on these issues. You know, your choice of words is always a problem for us, really. We like that you follow almost all our shows, but, you know, you send messages and it's extremely difficult for us to read out on radio. We have Adeyemi Akim Adeni, who is saying the position of the justices is sound and the argument by Barrister Curtis is merely sentimental. We must open our mind and not close it to other reasons other than what you owe. The justices raised...
I quoted the law.
The justices raised issues that are incontrovertible. A petitioner who had 133,000 agents should have been able to produce an alternate results to challenge the declaration of INEC. Equity does not aid the indolent, in a simple maxim in elementary law.
But what he's saying is factually challenged.
Okay.
The man has
133,000
agents.
Agents, yes.
And then he's claiming that only 18,000 places rigging happened, which means he had agents there.
But
look at 18,000 and 130,000.
But the justices are saying that they could not specifically say
that's
which polling units.
That's what I explained. I explained that judges are the one who attach weight to the evidence that they saw.
Okay.
Not the petitioner.
So not that
look, even as witnesses from outside, what you heard, were you not astounded by what you heard?
Again,
some of the riggings that happened. But again, we are saying that judges don't follow the sentiments or the emotions.
It's what you present before them.
They deal with the facts.
Okay.
You understand?
As understood and decided by
them.
Okay.
And they will take the facts, apply precedent,
and put weight to it.
Apply the law. You understand? And then their opinion.
All right.
So
we have Adeyemi Akim Adeni who is saying, please, your phone number so that we can call in to counter the one-sided position of your guest. Okay, well, you have the phone numbers already. We have Afiz Olayinka Salawi saying, good evening, Mr. Fuad. I disagree with Barrister Curtis on most of his positions. In this judgment, no dissenting judgment. It's 5 versus 0.
So, is that the only reason why you disagree with me?
Well,
at least you should give your position.
So let's respect this decision. APC lost in Kogi Central to PDP. Nobody is analyzing and criticizing the judgment. We took our eyes away because the ruling party lost. I'm not a lawyer, but I predicted
That's
right.
The sentiment.
Well, I'm not a lawyer, but I predicted right most of the judgment of the petition, especially 25% in FCT. I can argue it anywhere with my citizenship, education, and the Constitution. The Supreme Court will uphold the Court of Appeal judgment, and the opposition will still pay fine to the court. You know, they were fined here. All right. Adeyemi Akim Adeni is saying, gentlemen, we need to be objective in dishing out information to the public. Some of us follow the issues as much, not more than the guys. Issue of watermark on the court judgment has been thoroughly trashed in many fora. Same way Nwokobia showed his bias and was roundly exposed by liberals. Bear in mind that liberals was genuine even pre-election. Well, I don't know. We have Shakira Gumbiade. You should have gotten some other lawyer to balance what Barrister Curtis is feeding the public with tonight. Well, okay. We have Mamuga Kentimi. But Barrister Curtis himself has said that even on their platform, they cannot all agree.
Look, what have I read them? I said, this was my personal observation. You said these people did not front load evidence. The evidence that you are asking them to front load was the same evidence you gave a subpoena for INEC to give to them. So where are they going to get it from?
So we have Mamuga.
People are not just logic. They just go by emotion.
Well, we have Mamuga Kentimi. We say, in my opinion, whatever the judgment of last week, there's need to reform our electoral system to avoid waste of time and resources. Nigeria should show a good example to other African nations who are looking forward to seeing something good to emulate. The government and INEC has a lot to convince the new voters who hopes were dashed because of the non-transmission of election results in real time as promised. Billions wasted on technology. INEC should not rejoice but do better next time. We have Akinde Semido who is saying the issue with Nigerians is that we don't talk or complain when we benefit from a bad system until it affects us. Most people who are complaining about judiciary now have praised judiciary in the past when the justice favored them. We have Sunday and your Chuku is saying, I'm disappointed with the 5 judges. They came to defend Tinubu non-democracy. Well, we have Osarem Winda Omorogbon who is saying, good evening, guests in the house. For the problem we're having in the country, is the judiciary, because even if you take these people to court, they will say go to court, nothing will happen. And then we have Tᴜɪᴛᴛᴇʀ Mᴜsɪᴄ saying, Fuad, you are a genius. Keep it up. Joseph is biased for APC. He's an obedient member. Joseph is not an obedient member. That one I know. And then we have Olumiwa Oludude. We saying,
I'm also biased
because
I analyze the law.
Olumiwa Oludude saying the problem is the lacuna in the constitution. How does someone prove beyond reasonable doubt with these numerous loopholes? We need an urgent salvation plan, but we need a complete overhaul of our constitution and the electoral law. All right, that's the more that we have on Facebook. I think we can still squeeze in 1 or 2 more calls before we call it a day on the show. Yes, Barrister Curtis.
You know the problem why most people don't want to participate in live shows is because people tend to carry their emotion forward instead of their logic.
But I think
the truth is that people look. I admit and I concede. You guys are all entitled to your opinions.
Definitely.
But they are not entitled to your own set of facts.
Well, okay.
And the facts are different.
let's take most likely 2 more calls and then we call it a day on the show. 09136000410. Yes, hello, good evening.
Hello.
Good evening. Yes.
Good evening, Mr.
You have to make it very fast. 1 minute.
Thank you so much.
1 minute.
Yes,
1 minute.
Whether people respect your opinion or not, me personally, I respect it 100%. And Mr. Joseph. But the question I wanted to ask is that what are the hope of the common people? And they said the way you are mentioning about what happened in Kenya, the way they are doing things, to know that they know what they are doing in Kenya. But in Nigeria, we know. In fact, I don't know what are the common hope for the people now. So the way they are doing things, nothing we can do. I support reform. Who are the people that want to do reform? Because all of them are benefiting from this thing. But I know that one day everything will be okay. But what are the hope of the common people in Nigeria now? Thank you so much.
All right. That's Mr. Tune from Akonwajo. 09136000410. 09136000410. We have a message here on Facebook. Kawade Olono Day saying the 25% FCT votes for would-be president of Nigeria is sacrosanct anytime, any day. Well, we'll wait for the Supreme Court to interpret that.
Look, as a Nigerian, my own simple conclusion is that the word "and" is a conjunction.
Good.
And we have it used in 2 places there. So I ask a very simple question.
Why take one "and" and leave the second one?
If someone had scored simple majority of votes and did not meet the second condition, which is at least a quarter in 2/3 of states,
and Abuja,
would the person have been sworn in as president?
All right, we have to just wait for the Supreme Court too. All right, we'll take the last call for the evening, and then we have a final take from the guests in the studio. Hello, good evening.
Here for you.
Yeah, good evening.
Yes, I think
your name again, sir.
Olakunle from Ojodu.
Oh, Mr. Olakunle, it's been a while. How are you doing?
Yes. I'm good, my brother.
All right, please.
I think people are just overwhelmed by emotions generally, and we need to just understand that the law is based on facts. These are facts that will not go away no matter how much you wish it away. So this problem has absolutely nothing to do with the judiciary. It has more to do with the lawyers, because they are the ones who understand the law, and they are meant to use the law to favor their whoever they are representing in court. Yes, if they are making schoolboy errors that the judiciary is lashing them on, then who do we blame for all these kind of things? So I think people should be more concerned about logic and facts than what I want, what I don't want, this is who I wish for. It doesn't work like that in law. The law is based on facts. Thank you, guys, and have a great day.
All right, thank you, Olakunle. I think that will be the last call for the evening. Barrister Curtis, your final take on the show.
So the issues that I raise are the issues that agitated my mind. And for those of you who think I am being partial, let me explain to you. If the law requires you to front load documents in filing your suit, but you don't have the documents, you go back to the same court to issue a subpoena to get the same documents, right? And it took a subpoena before the documents were brought to court. Why would the same court be saying you did not front load the same documents? The second issue I raise is eligibility. That why are we leaving eligibility alone to the party when the Constitution of the Federal Republic of Nigeria, that is higher than the party's constitution, has got issue of conditions for eligibility. And so we should be looking at that more, because once the person is elected, he's not going to serve the party. He's going to serve the country. So we should be looking at that. And I also talked about the Abuja. And I said, look, Abuja, this needs to go further to the Supreme Court so that this situation is clarified once and for all. Because there have been judgments on Abuja that actually didn't agree with what these justices did. Coming from the Supreme Court. And so you could argue that they abandoned the precedent that came from a higher court. So until these issues are resolved, and the whole thing is for the betterment of the country.
All right.
I mean, I'm not the presidential candidate. Fuad is not one. Joseph is not one. We're only simply saying we need better reform so that our election can be rancor-free.
All right. Joseph ജᴜ your final thing.
I want to just appeal to Nigeria that we should find a way to manage our expectation so that we don't break down emotion-wise or psychological-wise. Then the second one is this. I equally want to appeal to Nigeria to, if Nigeria must move forward, let us focus more on the governors.
Yeah, you have been talking about the governor.
On the governors. Let's focus more
that's
on the governor, because it is extremely very, very key. If the governor are doing very, very well, reform in the state electoral body, allow local government to actually
function,
then we will now say, okay, let's complement the effort from Abuja. But in as much as the governor is having free time,
do whatever they like,
nothing will change. Nothing will change.
All right. So by Sakot is out.
And the president is the one that is blamed for everything.
Well, all right. We'll continue to talk about it. Like I said, Political Roundtable will be a platform to set the agenda. And I think the agenda that we've been able to set this evening is to talk about electoral reforms. We need to reform our electoral process so that we don't go into 2027 having this same problem that we've been having from 1999 till date. The question is, who will bail the cat? Who is going to go into the process of reforming our electoral system to give us a more credible election in Nigeria? That's a big question. Well, this is where we call it a day on Political Roundtable, mainland 98.3 FM. My name is Saheed Fuhad. Let's do this again next week.